And welcome. We'll just wait a couple of minutes while we let our attendees start logging in and getting themselves set up, and then we'll make a start. Thanks for joining us. Thanks for your patience and thanks for joining. We'll just wait a couple of minutes while we wait for our attendees to join and get themselves set up. Kia ora, good morning. We'll start in a minute or so. We're just waiting for everyone to join in. Kia ora, good morning. We'll just wait for everyone to join in. We have about 600 people registered, so we want to give people time to start. We've had a question come through about taking notes. It's a good idea. However, there are handouts that are detailed that we have either emailed you or available on our website, and the links will come through in the chat to those. We're also recording this session, so you will get a chance to watch it later if you need to. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Ngā mihi nui ki a koutou katoa. No mai, haere mai. It's my pleasure to welcome you to the first of our 5 in-depth seminars on the changes to the credit laws. Many of you will have attended our overview seminar a couple of weeks ago. And if you missed it and you want to see a high-level summary of the Commission discussing the 5 main areas that are changing, which are responsible lending, due diligence, directors' duties, fees and advertising, and certification, as well as hearing from Commission leaders discussing the education and enforcement approach the Commission is taking, then you can find a recording of that session on our website. The link has just popped up in the chat. We also made a series of informative handouts detailing the main changes that are underway. If you've not received these, you can email us, or they are available on our website. And again, a link's going to pop up in the chat function. So I'd like to thank you all for filling in the surveys at the end of the last seminar. Your questions were thoughtful, relevant, and helped us make sure that these in-depth sessions deliver information that you want to hear about. So, as you know, we have used your queries to structure today's discussion, and we hope that's useful for you. As you know, today's seminar focuses on responsible lending, and our expert, Mark Atwell, will be addressing some of your key questions. And if we get time, he'll be available for a more informal Q&A chat session at the end. There's also a chance to put more questions forward to us with a survey at the end, just like we did last time. But first, I'll open with karakia. Whakataka te hau ki te uru, whakataka te hau ki te taonga. Kia mā kena kena, ki uta, kia mā tara tara ki tai. E he aki ana te atakura, he tiu, he huka, he hauhunga, te hei mauri ora. Before inviting Mark to speak to you all, I'll quickly go over some housekeeping. If you have a technical issue, please raise your virtual hand. It's under Reactions on the bottom right of your screen, and we will see if we can assist you in the chat function. You can also use the chat function to ask questions that arise for you during our discussion today. Penny Fitzpatrick is handling our Zoom, and I'd like to introduce you to her now. Welcome, Penny, and thank you so much for helping us out here. So Penny has been popping the links in the chat, and she's also available if you happen to have an issue in your with your technical difficulties, and you pop a little question or a problem that you're having in the chat function. Penny will see if she can resolve that for you. So I think rather than introducing Penny, we'll get straight on with it. So I can see that we're getting really, really close to our 600 mark, which is just fantastic. I would now like to start to introduce Mark Atwell. He's a principal advisor at the Commission. So he's an expert with a significant amount of knowledge and experience. And he's spent some time drilling down into the details so that he can give you lots of information about the changes. There's a large amount of facts and details to consider in this session. So as I said before, we are going to record it so you can refer back to it. And we're going to put lots of links in the chat so you can read things like the code, responsible lending code, the guidance and the legislation that Mark is referring to at a later date or during the session if you wish to multitask. I just want to say this session's supposed to run for 45 minutes, but we suspect it's going to run over. And if you have to go, don't worry, we'll email you a link to the recording and you can pick up where you left off at a time that suits you. And now I'd like to welcome Mark Atwell to discuss responsible lending with us. Morena, Mark.
Thanks, Sonia. As noted by Sonia, my name's Mark and I'm a Principal Advisor in the Credit Branch at the Commerce Commission. So in this webinar, I will briefly summarise what I covered in the earlier seminar in relation to the upcoming changes to responsible lending obligations. And I'll answer some of the questions that lenders have put to the Commission, either in person at the lender seminar in Wellington last month or through completion of an online survey. So we've received a lot of questions in relation to the changes to responsible lending obligations. The vast majority of which were about compliance with the new regulations around affordability assessment. This is perhaps not surprising as we appreciate that the application of the regulations may not always be straightforward in all circumstances. As John Lyle, Investigations and Compliance Manager in the Commission's Credit Branch, noted in the earlier lending seminars, we recognise that through implementation, you will come across issues that may give rise to some uncertainty or challenges in relation to how lenders interpret or apply the law. So we would encourage you to contact us with these uncertainties and challenges, as this will help us to understand the areas that lenders might be finding particularly challenging and where the Commission might be able to issue written guidance about our expectations or approach to assist lenders. So while I'll endeavour to cover as many questions as possible, don't be offended if I don't cover your questions today. As I said, there's a huge number of questions for this topic, so our aim is to cover the questions that seem to be causing lenders most concern. And there are also one or two questions where we wanted to do some further thinking before saying anything publicly about our approach.
Yeah, Mark, we did receive many dozens of questions, which is fantastic. And many of them are covering similar themes, and some of them are quite complex. But I wonder if perhaps you talk about the changes to the law, it might be useful to quickly set out what lenders' obligations are currently.
Thanks, Sonia. First of all, I think as we all know, lenders are required to comply with the lender responsibility principles found at Section 9C of the Credit Contracts and Consumer Finance Act. So, and lenders are creditors under consumer credit contracts, i.e. non-business lenders, and mobile traders as defined under the Act will also be treated as lenders. And the principle is that lenders must at all times act with the care, diligence, skill of a responsible lender in their advertising, before they enter into a loan or a relevant insurance contract or a guarantee, and in any subsequent dealings with the borrower, the insured or the guarantor. And lenders must also comply with the lender responsibilities, and that's sort of what we're going to focus on today. And these include the obligation to make reasonable inquiries before agreeing to lend to a borrower, so as to be satisfied that it's likely that the loan will meet the borrower's requirements and objectives, i.e. that the loan is suitable, and it's likely that the borrower will be able to make payments due under the loan without suffering substantial hardship, i.e. that the loan is affordable. And the Responsible Lending Code provides guidance to lenders about how they may go about complying with their responsible lending obligations. So the code is not law, but the Act says that evidence of compliance with the provisions in the code is to be treated as evidence of compliance with the law.
Thanks, Mark. One other thing that we've been thinking about is we know that many people who will be watching this video and this webinar will be acutely aware of the October 1 start date and the impact COVID lockdowns are having on their ability to implement the changes. Can you update people about the government's decision?
Yes, so the changes to responsible lending obligations are now taking effect on 1 December 2021. So they were due to take effect on 1 October, but in view of the current COVID-19 lockdown, the government has announced a delay to these changes until 1 December. So the delay allows more time for lenders affected by COVID-19 to make the necessary changes to their systems and processes and staff training to implement the changes. So the three key responsible lending changes are, first, as well as making suitability and affordability inquiries before entering into a loan, lenders, well, a new loan, lenders will need to make the same inquiries before making a material change to a loan. So the term material change is defined and covers increases to the credit limit or where the lender is looking to make an additional advance they didn't take into account when they completed their original assessment. Secondly, lenders will need to take specific steps set out in regulations in order to satisfy the requirement to make the inquiries needed, and I'll talk about this shortly. And finally, lenders will need to keep records of the inquiries that demonstrate how the lender has satisfied itself that the loan was suitable and affordable, including the inquiries made and the results of those inquiries. And lenders will need to keep copies of those records for 7 years. Borrowers can ask lenders for copies of those records, as can the Commission, approve dispute resolution schemes. And if you're asked to provide a copy, you must do so within 20 working days. I think it's important to note that borrowers' representatives can ask for records as well, so you'll need to ensure that you've implemented systems and processes to enable you to respond to the volume of requests for records within the required time frame. The responsible lending code's also been revised to include additional guidance for lenders about how they can comply with these new requirements. And the updated code again comes into force from 1 December, except Chapter 12, which deals with lenders' obligations when borrowers suffer from repayment difficulties, and those changes come into force 1 February. So we've placed a link in the link to the code in the chat.
That's great, Mark. Thank you. So thinking about our suitability then, what can you tell us about the suitability assessments?
Well, from 1 December, as part of the obligation to make reasonable inquiries to be satisfied that it's likely that the loan being offered meets the borrower's requirements and objectives, lenders now must comply with the minimum requirements for inquiries and assessments set out in Regulation 4AA. So these regulations are law, and failure to comply with the regulations will be a breach of the responsible lending principles. So the new rules are set out in the Credit Contracts and Consumer Finance Lender Inquiries into Suitability and Affordability Amendment Regulations 2020. It's a bit of a mouthful, and we've put a link to those amendment regulations in the chat, or shortly we'll do. And the regulations require that lenders make reasonable inquiries to determine listed aspects of the borrower's requirements and objectives, including but not limited to the amount of the credit that's sought, the purpose for which the credit sought, the loan term sought. And lenders must then make the suitability assessment required by the Act, i.e. that it's likely that the loan meets the borrower's requirements and objectives, taking into account the results of complying with the obligations and the regulations and any other reasonable inquiries they might, on top of that, required by the suitability lender responsibility. And here's a section number for you, Section 9C3AI of the Act.
It's hard to take all those numbers in, Mark. We'll try to do as much as we can to pop them in the chat. And I see we've just had a question come through about buy now, pay later. We're going to cover that off later in the session, so stay listening. I know some lenders will be wondering, when we think about an inquiry, what does that actually mean? What constitutes an inquiry?
Inquiry is not a defined term under the Act or the regulations. And in our view, it includes asking questions or otherwise seeking information or documents from the borrower or other third party, and then considering and analysing the information or document provided.
And then what level of record keeping is required for these suitability assessments? We had one question come in which described a third party making the original assessment of product fit. but the third party was not authorised to give regulated financial advice. What are the lender's obligations in that type of situation?
Well, the lender's obligation under the Consumer Credit Contracts and Consumer Finance Act is to ensure that it's likely that the loan to ensure that it's likely that the loan is suitable. That obligation remains with the lender and not the third-party financial advisor or other intermediary acting on behalf of the borrower. So lenders must keep records about the inquiries made by the lender under Section 9C, and the records must demonstrate how the lender has satisfied itself that the loan was likely to meet the borrower's requirements and objectives. And the revised code contains guidance for lenders around the detail of record keeping for suitability assessments at paragraphs 4.14 to 4.16. And a copy of these paragraphs will be placed in the chat, and I won't sort of read through them. Yeah. I will say that the code at 4.5 does say that where lenders receive information from financial advisors or other intermediaries acting for the borrower, they can treat that information provided to it as though it had been provided to the lender by the borrower. And lenders should also require financial advisors and intermediaries to implement and maintain appropriate processes and procedures to collect the information from the borrower and make any necessary inquiries, and to train their staff on the code and the lender responsibility principles. And just to talking about suitability, remember that the loan provider doesn't have to be the most suitable loan. It just needs to be among a range of loans that are likely to meet the borrower's requirements and objectives. And any obligation that a financial advisor may have under the Financial Markets Conduct Act 2013 when providing financial advice is separate from a lender's responsible lending obligations.
That's fantastic, Mark. So I just want to note that someone's asked a question about consumers. We are running consumer advisory sessions in a couple of weeks, and we'll also do our best to make sure that borrowers are also informed about these changes. And Mark, so what about mobile traders? What do they need to be doing? Are their obligations any different?
No, mobile traders that come under the Act will have all the same obligations as any other lender, including responsible lending, suitability and affordability assessment obligations. Mobile traders will be caught by the Act if they are a creditor under a consumer credit contract, or if they fall within the definition of mobile trader under Section 5 of the Act. So traders should review the definition for themselves, but it includes a person who supplies goods to consumers outside of fixed premises on deferred payment terms. And the Act treats these contracts as consumer credit contracts, even though they may not meet the technical definition for a consumer credit contract under the Act. So, and the regulations set out information that lenders must collect from borrowers as part of assessing whether it's likely that the loan's suitable. And one of the aspects of borrowers' requirements and objectives that lenders must determine, which is perhaps more relevant to mobile traders, is Regulation 4AA2G, which says that if the agreement is a credit sale and the property that is subject to the credit sale is not to be given or sent to the borrower within 20 working days, then when does the borrower actually want possession of that property? So we would also encourage mobile traders to have a look at our May 2020 mobile trader guidelines, which are available on our website. And I think we're looking to place a link to that in the chat also.
Yes, and our thanks to Kate, who's placing those in the chat for us. So we've received a question about add-on insurance products. Can you talk to us about how suitability should be determined for add-on insurance products?
Yes, so Regulation 4AB sets out the minimum requirements for assessing suitability of repayment waivers, extended warranties that are financed under the loan, and relevant insurance contracts. So, under this regulation, lenders must make reasonable inquiries into the following things. So, determining whether or not the borrower has existing cover or rights under the CGA to protect against the risks that you're seeking to protect against, whether the borrower's employment status or residency might make them ineligible, or age might make them ineligible for some of the benefits under the proposed products, whether the products have the benefits that cover that the borrower requires, and then whether they accept the costs of the product. And then lenders must then make the suitability assessment that the products are going to meet the borrower's requirements and objectives. Also refer to Chapter 9 of the Code, which provides guidance around responsible lending obligations and in relation to these products. And we'd also note it's not just in the responsible lending principles are there obligations under the Act, there are also other obligations relating to these repayment waivers, extended warranties and credit-related insurance under the CCCFA, including a prohibition on making unreasonable requirements in relation to these products, there's disclosure obligations, and there are obligations around rebating premiums on early repayment of the loan. And just finally, for completeness, would note that where lenders are selling extended warranties as defined under the Fair Trading Act, then there'll be obligations under that Act also.
Of course. That's great, Mark. So I wonder if we should move on to affordability assessments now.
Thank you. And I think that pretty much the rest of the seminar will be focusing on affordability assessments. So from 1 December 2021, as part of the obligation to make reasonable inquiries to be satisfied that it's likely that the borrower can afford to make payments on the loan without suffering substantial hardship, lenders must comply with the minimum requirements for inquiries and assessments as set out in regulations 4AE to 4AO. As with the suitability assessments, these regulations are law, and failure to comply with these regulations will be a breach of the law.
Assessing affordability would often be a complex process. I know there's a flowchart on the Responsible Lending Code, isn't there? Do you want to tell us a little bit more about that?
Yes, so Chapter 5 of the revised Responsible Lending Code at page 25 contains a diagram which may help lenders when assessing affordability. The diagram is commentary only and for illustrative purposes and does not represent every step or legal test provided by the regulations. So it's a helpful aid, but it's not a substitute for working through the regulations. And yeah, so the regulations require that lenders make reasonable inquiries to enable the lender to estimate over the relevant period the borrower's likely income and the borrower's likely relevant expenses. And then Regulation 4AF2B then requires that lenders must be satisfied on reasonable grounds that it's likely that the borrower will make the payments without suffering substantial hardship because the borrower's likely income exceeds their likely relevant expenses, and then there's one of the following two things. It's either a reasonable surplus or there's reasonable buffers or adjustments included in the income and expense estimates.
What's a reasonable buffer? I mean, how will the Commission determine what reasonable is?
I mean, also, as set out in the regulation, the buffer or surplus must be adequate to address the risk that the likely income has been overestimated or the likely relevant expenses may be underestimated, or that the borrower is incurring other expenses that cause them to suffer substantial, other unexpected expenses that cause them to suffer substantial hardship. So it is what it is, but reasonable buffer or adjustments and reasonable surplus are not defined in the regulations or the Act. However, the Responsible Lending Code does contain guidance at paragraphs 5.8 to 10 about how lenders might go about assessing the adequacy of these buffers or surpluses. In particular, paragraph 5.10 says that while the amount of the surplus or buffer adjustment is not prescribed, must adequately assess the risk we've discussed, and determination of what is adequate will depend on the nature of the credit and the risk that the income's been overstated or understated. And it gives the example of a buffer adjustment may depend on the size, term, or evolving nature of the credit product. And a surplus or buffer adjustment may be a percentage, or it can be an absolute amount. So I suppose in terms of the Commission determining what might be reasonable, we're going to be guided by the regulations and the code, and then just the particular circumstances of the loan.
We had a really interesting question come through regarding uncommitted monthly income. And I thought this was a good time to go to this question. A lender asked if there was a minimum UMI that the Commission expects to see. So they gave an example of a pensioner who's likely to have a much lower uncommitted monthly income, but maybe more used to managing their monthly expenses and budget.
I think that the simple answer is there's no minimum UMI. It's not prescribed as a dollar figure anywhere. And so Chapter 5 of the code does provide some, as I mentioned, some guidance to lenders. So the code suggests at 5.8 and 5.9 that lenders should seek to have a consistent set of surpluses and buffers across the credit products to, and that it also suggests, but you can have different surpluses or buffers across the credit products to reflect different risks of those products to affordability. For example, lenders may apply a different uncommitted monthly income requirement for a lower risk loan as compared to a higher risk loan.
Another interesting question around affordability. It asked, Does the Commission have a recommended ratio of income to expense that lenders could use when calculating affordability?
Again, the Commission doesn't have a recommended ratio. And as discussed, the obligation is to ensure there's a reasonable surplus or reasonable buffer in the assessment. The code indicates these should be consistent across the products. I mean, income to expenditure ratios may be a tool that lenders can use to assist them in their assessments, but the ultimate question is whether there's a sufficient surplus and or buffer. And in particular, we would ask that lenders be mindful, if they are using these ratios, that it provides a sufficient surplus in absolute terms for borrowers at lower levels of income. So the regulations prescribe the way that lenders must estimate the borrower's likely income.
Thanks, Mark. We're getting some lovely questions and comments through. Everyone's enjoying the information that you're giving us. Thank you so much. We had a question come in about gathering information to make assessments. The question asks, when asking about a customer's income, do I need to ask for the employment contract, or is 3 months bank statements or 3 months payslips okay?
Regulation 4AJ3 provides that when the lender's estimating the borrower's likely income based on asking the borrower about their source of income, the lender must then verify that based on reliable evidence, or if verification is not reasonably practicable, they can consider whether the source and the amount of the income is realistic. So we would expect in most circumstances that 3 months of bank statements or 3 months of payslips should be sufficiently reliable evidence. What
about seasonal workers? How should lenders approach assessments for seasonal workers whose hours may be cut after the assessment?
The code suggests at paragraph 5.13 that lenders should consider adjusting volatile or irregular income or variable income by, for example, discounting the seasonal income or bonuses or overtime.
Right. So what about this question? How do lenders avoid unintended consequences of affordability assessments, such as discriminating against elderly people or pregnant women?
So the commentary to Chapter 2 of the Code provides guidance on discrimination and compliance with the Human Rights Act 1993. So as per the guidance, lenders mustn't refuse to lend or apply different rules or principles to borrowers simply on the basis of their age, pregnancy, or any of the other protected characteristics. I mean, at the same time, these factors, they do have the potential, or some of them have the potential to affect the borrower's future income and expenses. And so they will be relevant in a lender's assessment about whether a particular borrower can likely make payments on the loan without substantial hardship. So as part of assessing the borrower's likely income, the regulations require that lenders must, quote, ask the borrower about any likely changes in income, end quote. So, I mean, this is going to provide an opportunity for the lender to discuss with the borrower the sort of potential, say, retirement during the loan. For example, are they still going to have sufficient income to meet the loan payments and other expenses? And does the borrower intend to sell any of their assets? As well as any other known issues such as likely anticipated new childcare obligations, and sort of assess the effect that all this might have on the borrower's income and expenses.
We had a similar question, which I think is worth canvassing here as well. And it asked, how should lenders approach a borrower's pregnancy during the term of the loan agreement?
As stated, lenders will need to apply the same principles and abide by the same obligations they would with any other borrower. So we wouldn't expect lenders to be taking any additional steps just because they became aware of a pregnancy, after the loan had been advanced. Although you may need to be mindful of at least the potential for there to be some repayment difficulties and mindful of the guidance in this regard under Chapter 12 of the Code. So turning now to sort of calculation of likely relevant expenses under the regulations. And it sort of sets it out as a two-stage process. First, making an initial estimate of the borrower's expenses, including making inquiries about whether any financial commitments may have been omitted. And then the second stage is a sort of a verification and expense adjustment sort of phase. So Regulation 4AK sets out their first stage for making the initial estimate of the likely relevant expenses.
Thanks, Mark. There's many complexities when assessing affordability of a loan. And one lender asked, how should lenders verify whether a customer has other loans when this isn't necessarily captured on a credit report? Can a lender rely on the information provided by the borrower?
The code provides the following guidance of paragraph 5.4. So subject to the requirements and the regulations to verify any particular information about income and expenses, lenders can rely on the information provided to them by the borrower, unless they've got reasonable grounds to believe that the information is not reliable. So where the lender has reasonable grounds, the lender should then take reasonable steps to verify the information provided. So as part of making an initial estimate of the borrower's likely relevant expenses, the regulations require that the lender must make reasonable inquiries about whether any financial commitments have been missed from the initial estimate. So for new loans, the inquiries must include getting a credit report, and where the credit report discloses debts that weren't disclosed by the applicant, then we would expect lenders to be making further inquiries with the borrower about these. And where the lender obtains 90 days worth of bank transaction records as part of the second stage verification and expense adjustment phase, those records may show loan payments on loans not disclosed by the borrower to the lender. So this would be reasonable grounds to believe that the initial information provided by the borrower about the loan payment expenses is perhaps not a complete picture. And again, we would expect the lenders to be making further inquiry of the borrowers about these new loans. So generally, taking these steps should allow a lender to verify other loans the borrower may have. I mean, in rare cases, if there continues to be inconsistency between what appears on the credit report / bank statements and what the borrower is telling a lender, then the lender may, with the borrower's consent, need to make further inquiries of other loan providers.
We've got a question here which asks about outgoings as expenses as opposed to discretionary spend. Do you want to talk a little bit about that?
Okay. In order to calculate an estimate of the likely expenses, a lender must estimate the listed outgoings for the relevant period. So listed outgoings are defined in Regulation 4AE and include A, fixed commitments, B, payments on any debts, C, living expenses, including food and groceries, and D, and I'll read this one out in full, any regular or frequently recurring outgoings, for example, savings, investments, gym memberships, entertainment costs, or tithing that are material to the relevant to the estimate of the relevant expenses, and that the borrower is unable or unwilling to cease after the agreement is entered into or materially changed. So outgoings falling within any of these categories will be relevant expenses. On the other hand, discretionary spend will be outgoings falling outside of these categories, and regular and frequently recurring outgoings that the borrower is able and willing to reduce. So for example, discretionary spend may include some recurring entertainment costs, e.g. eating out, alcohol, movie tickets, so long as the borrower has confirmed and the lender has verified that they are willing and able to cease these outgoings. So we would say, but before classing any food-related entertainment costs as discretionary spend, the lender must, of course, be satisfied that there's sufficient money been allocated for food and groceries under living expenses. So, for example, if takeaways is to be reduced, spending on groceries will need to increase, although perhaps not necessarily by the same amount.
That's fantastic, Mark. Thank you. And I hope that clarifies. We were starting to get a few questions through about that discretionary spend. I hope that clarifies things for people. So when we were thinking, one of the questions that came through after the high-level seminars a couple of weeks ago talked again about discretionary spend. And it said, how practically do lenders differentiate between expenses and discretionary spend when this is difficult to reconstruct from bank statements?
So I think in practical terms, when calculating the initial estimate of relevant expenses, lenders will need to ask the borrower about each category of expense. And for reoccurring expenses, determine whether these outgoings the borrower is willing and able to cease after the loan. So getting high quality information from the borrower at the initial investment phase should assist with distinguishing between expenses and discretionary spend based on bank accounts and other reliable evidence at the verification stage. So if the bank statements and other reliable evidence show higher outgoings than the initial estimate, then lenders must make further inquiries about this with the borrower and adjust the assessment accordingly. When adjusting the initial assessment, lenders must also consider whether the relevant expenses are at a level that would be below a reasonable minimum cost of living for a person in similar circumstances to those of the borrower, and if so, increase the amount of the expense to a reasonable minimum cost.
You know, a huge portion of our population lives week to week. And the fact that they have no money left at the end of the week does not necessarily mean that they can't afford to loan. although would their discretionary spend have to go down?
So lenders may be able to work with borrowers to determine what outgoings they are willing and able to reduce. However, the lender must have verified that these come from the borrower's discretionary spend, and relevant expenses as defined in Regulation 4AE cannot be reduced.
And then how do you define regular expenses and how do you group them? For example, I mean, you've talked a little bit about entertainment. How do you approach reoccurring entertainment expenses?
I think, as mentioned before, Regulation 4AED says regular expenses are any regular or frequently recurring outgoings, for example, savings, investment, gym membership, and entertainment costs or tithing, that are material to the estimate of the relevant expense and that the borrower is unable or unwilling to cease after the agreement is entered or materially changed. So these are separate to and in addition to the financial commitments, payments on debts, and living expenses, which must be first assessed. So I think the examples given there provide an idea of the types of expenses to be considered and how they should be grouped. In estimating relevant expenses, lenders should ask the borrower about any recurring expenses or activities, including entertainment, to determine the amount spent on a weekly or monthly basis, and to the extent which the borrower is willing or able to reduce these after the loan. Again, if at the verification stage bank statements show higher, regular or frequently recurring entertainment expenses, lenders would need to make further inquiries and or adjustments with the borrower. Benchmarks may also assist if they contain a component of allowance for entertainment expenditure, for example, a household expenditure benchmark.
That's super useful, Mark. So then how do you determine if a cost is material to the estimate?
So Regulation 4AED only requires lenders to consider recurring outgoings as relevant expenses if they are material, meaning, I suppose this means that immaterial or genuinely minimal outgoings will not be captured. So I mean, as yet, there's no legal precedent on when recurring or frequent outgoings will be material to the estimate. So given this, we would suggest that lenders adopt a relatively conservative approach, for example, by taking into account whether the outgoing is significant in dollar terms, even if it's low in dollar terms, whether it's significant due to its frequency, or whether the outgoing is significant due to its importance, i.e. how likely is it that the borrower to give up that expense.
Hey, there's an interesting question that we've got here. How should interest-only loans be treated?
I suppose for interest-only loans, where the interest-only period is shorter than the term of the loan, the code suggests that lenders should consider assessing the borrower's ability to repay the loan on a principal and interest basis, excluding the interest-only period. So, for example, if the loan term was 5 years and the interest-only period was 1 year, then you should assess affordability over the 4 years principal and interest. The code also suggests that where you've got a floating interest rate or a variable interest rate, that lenders should take account of the fact that interest rates can rise and consider applying a buffer to the interest rate to mitigate the risk of that increase. Might have potential for it to adversely impact the borrower's ability to pay. So once a lender has made an initial estimate of the borrower's likely relevant expenses, the lender then needs to move on to a second stage, which is set out in Regulation 4AM, which involves sort of a verification and adjustment of the initial estimate of expenses.
So making and then verifying those estimates are complicated. We've got one lender who asks, what are acceptable methods of making further inquiries regarding a customer's stated expenses?
Well, lenders can make further inquiry directly with the borrower, either verbally or in writing, requesting that they provide you additional information or documents, for example, bank transaction data or contracts or invoices. You can make further inquiry of third parties with the consent of the borrower, e.g. to get credit checks or other entities that the borrower might be making payments to. And further inquiries also may involve comparing stated expenses with benchmarkable expenses. And the regulations also require that a lender must consider whether the relevant expenses are at a level which would be below a reasonable minimum cost of living for a person in similar circumstances to those of the borrower, and if so, increase the amount of the expense to a reasonable minimum.
So when can lenders use benchmarks, and will the Commission provide more prescriptive benchmarks for calculating affordability and living expenses, things like that?
An expense is a benchmarkable expense if individually or as a group of expenses. It is an expense for which the lender may use statistical information about household expenditure, including utilities, food, groceries, and transport expenses. And those transport expenses can include fuel, WAF, registration, vehicle repairs, and maintenance. So there's no requirement for lenders to use benchmarks when considering these expenses. However, they can be used as an alternative means of verification in order to satisfy the second stage assessment of a borrower's relevant expenses. So verification of living expenses is not always straightforward based on bank statements, and the use of benchmarking can provide some protection against the risk that the borrowers may have inadvertently under-recorded these expenses. And lenders who choose to use benchmarks for the verification stage must use the higher of the benchmark or the initial estimate. So to answer the question, really, no, the Commission will not be developing and publishing benchmark expenses for use by lenders. So lenders are able to develop their own benchmark expenses or use benchmark expenses provided by others, or developed by others rather, provided the statistical information meets the requirements in Regulation 4AN2. And I won't repeat those, but I think we're going to place a copy of that regulation in the chat.
Yes, I'm pretty sure Kate can do that for us, because there's some good detail there that's useful to people. So when reviewing expenses and looking at benchmark expenses for a similar customer, are these individual expense details or are they looking at an overall expenditure? And if a lawyer can, if a lender can prove that the customer pays lower than that of a customer in a similar situation, can a lender continue with the lower amount, provided they can, prove it and note why, that recording element? And if not, how do you ensure that someone isn't getting penalised for having a different situation to most, such as higher income or living with flatmates?
So, after a lender has made the initial assessment of a borrower's likely relevant expenses, so the Regulation 4AM2 requires that a lender must then, to the extent that the estimate was based on asking the borrower about their expenses, or if there's a significant risk of underestimation of expenses, must verify the expenses with reliable evidence, and or for benchmarkable expenses, use the higher of the initial estimate and the benchmark. So, and if none of those is reasonably practical, you can adjust the expense by estimating a reasonable cost. So we would expect that benchmarks would be categories of expenses that could vary from the narrow, to food, or they could be quite broad, just living expenses. So, but where a lender is able to verify actual expenses based on reliable evidence, then they do not need to utilize a benchmark for that expense. And even after the expenses have been verified, the regulations, as I've said a couple of times already, require that lenders must consider whether the relevant expense is at a level that would be below a reasonable minimum cost of living for a person in similar circumstances as the borrower, and then, if so, increase the amount of the expense to a reasonable minimum cost.
That's fantastic. And I hope that answers the questions that we've been getting coming through regarding people who might be living off grid or able to have a different outgoings. Now, I just want to note that it's nearly 10:15, which means we've just about to cross over our 45-minute time frame. Mark and I are going to keep going. And you are welcome to stay with us. We've got some really interesting information coming up, including Buy Now, Pay Later, which we're going to get to. But if you do have to go, if you've got another meeting or something else on, we are recording this and we will email you the link and you can pick up where you left off. So there's a question come through, Mark, now that says, would a customer's previous purchase or payment history be a valid method in considering affordability?
The obligation under Section 9C3A2, that's the responsible lending principle, is to make reasonable inquiries to be satisfied that it's likely that the borrower can make payment on the loan without substantial hardship. And the new Section 9C5A then provides that reasonable inquiries include a requirement to comply with the regulations. So while the regulations don't mention payment history, the regulations set out the minimum inquiries and assessments. So accordingly, a lender can consider payment history as part of their affordability assessment, so long as it's an addition to and not a substitution for the assessments required under the regulations.
There's a question about the Commission's expectation with regard to lenders verifying revolving credit and overdraft or credit card limits.
So the regulations set out specific rules around how lenders must determine the estimate of likely relevant expenses for payment under revolving credit contracts that have credit limits. So, and that's in Regulation 4AL2, which again, we will set out in the chat. And I won't run through them. So where verification of the credit limit is not reasonably practical, we would expect that a lender could rely on what a borrower has told them about the credit limit, unless the lender had reason to believe that the limit advice was not accurate.
And there's a question come through that sort of relates to that. Using credit card checks as a verification tool is not mentioned in the code, and the lender says they can't see how to do this.
So Regulation 4AM provides that as part of the process for adjusting the initial estimate of likely expenses, the lender must verify the amount of the expenses with reliable evidence, which may include, or that's one of the options, recent transaction records for a period of at least 90 days from a bank account from which those expenses have been paid, or a copy of a contract of an invoice or any other reliable evidence. So I think in our view, we would view credit card bank statements are likely to be considered transaction records from a bank account from which those expenses have been paid. And if that's not right, if they're not bank accounts, then they're likely to be considered other reliable evidence.
Other reliable evidence. Yeah, that makes sense. What about this question? If the lender can't verify the estimate against reliable evidence, what does the Commission view as an acceptable alternative?
I suppose in terms of expenses, Regulation 4A provides two alternatives to verification by reliable evidence. So benchmarkable expenses can be verified using the higher of the initial estimate or an appropriate benchmark. And if neither verification by reliable evidence or benchmarks is reasonably practicable, the lender may adjust the expenses by estimating a reasonable cost for that expense. So benchmarks, obviously the preferred alternative where reliable evidence is not available to verify the expenses, and they should assist in many cases. And if verification by evidence or benchmarks is not possible, lenders should just keep careful records of how they have estimated the reasonable costs or amounts. But lenders should also bear in mind that an inability to verify material aspects of income or expenses may indicate the loan is not affordable.
Yes, that makes sense. Okay, so we've had quite a few questions come through about buy now, pay later and afterpay and things like that. So I think it would be a good time to get to that material now. One of the questions that's come through says, does the Commission plan to regulate buy now, pay laters, such as afterpay and lay-by, etc.? The lender in the question says these pose a considerable risk to affordability as they do not currently fall under the code.
I think it's right that buy now, pay later arrangements are not typically consumer credit contracts under the Act. So they don't meet the definition in Section 11 because there's no interest or credit fees charged nor is any security interest taken. So the only fees typically are default fees, and these are not credit fees for the purposes of the Act. So because buy now, pay laters are not consumer credit contracts, they're not currently governed by the responsible lending rules. So the Commerce and Consumer Affairs Minister, David Clark, announced in June 2021 that the government is looking at options for regulating buy now, pay later, including bringing it within the triple CFA, and that IMBI is looking to issue a discussion paper later this year on possible regulation options. Whether or not buy now, pay later is regulated under the Act will be a decision for the Minister and Cabinet and not for the Commission.
That's great clarity, Mark. Thank you. So then, I think it's still worth diving into this a little bit because there's, lots of comments about this. If factoring in standing buy now, pay later payments, does the lender have to factor in repayment amounts as if the full purchase limit has been utilised? Or can affordability be calculated on the outstanding amount on the facility at the time of the assessment?
So If the buy now, pay later arrangement constitutes a revolving credit contract as defined in the Act, then that has a credit limit, then lenders will need to calculate the expense in accordance with Regulation 4AL2. So a revolving credit contract is defined as meaning a credit contract, whether or not the contract specifies a credit limit, if the contract anticipates multiple advances to be made when requested by the debtor in accordance with the contract, and doesn't limit the total amount that can be advanced to the debtor under the contract. So if the buy now, pay later arrangement is not considered a revolving credit contract, I suppose the conservative approach would be to assess the expense on the basis that the full purchase limit had been utilised, and that required payments would be made on that basis, e.g. fortnightly payments. Although lenders may be able to tailor the approach based on information and evidence from the borrower about actual use of the facility, for example, if it's just a one-off purchase and the outstanding balance has been verified.
Brilliant, that's great. So I'll just remind everyone, the recording to this session will be emailed out to all people who have registered to attend this session. So there's a question here about credit limits. So how should lenders set credit limits for monthly consumer accounts? Like, those that might fall due on the 20th of the month following.
Assuming this is a revolving credit facility caught by the responsible lending principles and regulations, the same rules as always will apply. So lenders must first consider the suitability. So the credit limit should match rather than exceed the borrower's needs. And lenders must then assess the affordability with the monthly limit being no higher than what the borrower can affordably make payments on for an ongoing basis.
That's great. Hey, so we've got a question here about someone who's working through a mortgage broker, and we'd be interested in your thoughts on this. So it says, my situation is that I work through a mortgage broker who does all the due diligence, etc. He then sends me the arrangement. I go to see the client, and if I feel happy with the proposal, I then send the client a letter of offer, which they sign and return if it suits them. Where do I stand with all this legislation? I do not give any financial advice. I only do first mortgage loans, and they are usually short term, up to 12 months.
As sort of advised in response to a similar question in relation to suitability assessments. So lenders retain the responsible lending obligation under the Act to ensure that loans are both suitable and affordable, even where the borrower engagement is through a mortgage broker or other intermediary. So, I think if lenders are unsure about how the rules apply to them, they need to obtain some legal advice.
It's always a good thing to do. How about this one? Where variation to increase a limit is of a minor nature, say less than $1,000, and the repayments remain more or less the same, would it be necessary to process a new assessment of bank report data?
That's an interesting question. So, all increases to credit limits are caught by the material change definition. So, from 1 December 2021, under Section 9C3(2), lenders will have an obligation to make reasonable inquiries to be satisfied that the loan is affordable prior to making material change to a loan, and not just before the loan agreement is first entered into. So the definition of material change includes where the credit limit is increased either by agreement with the borrower or where the lender exercises the power to do so. So this means where the credit limit is increased, lenders will need to conduct a new affordability assessment in compliance with the regulations, even where the increase to the limit is modest and the loan payments remain similar. So Regulation 4AG does provide an exception from the obligation under 4AF to undertake a full income and expense estimate, where the lender makes inquiries that are sufficient to establish that it's obvious in the circumstances of the particular case that the borrower will make the payments under the agreement without suffering substantial hardship, so as to make the inquiries required by Regulation 4AF disproportionate. So this exception is intended to be a high test. That the code gives the example of someone earning $350,000 per annum with net assets over $1 million, wanting a 10 grand credit card for airpoints. So we would think perhaps another situation where the exception may arise is with a long-term mortgage or home loan, where the credit increase is plainly minor compared to the total loan amount, and the records the lender holds clearly demonstrate the borrower's income and expenses make the loan affordable. So whether the exception applies will depend not just on the actual amount of the credit increase, but on all the circumstances. So for example, a $10,000 top up on a $500,000 loan, dollar loan repayable over 20 years is very different to a $2,000 increase on a $5,000 loan repayable in a year. So if the exception of 4AG does not apply, then the usual rules will need to be followed. However, in order to comply with the regulations on material change, a lender may not need to undertake all the same inquiries as when the loan was first set up. So for example, when making the initial assessment of the relevant expenses, lenders may be able to rely on recent and reliable information they hold and focus the new inquiries on whether there have been changes in either the income or expenses since the last assessment. So this will need to be verified, for example, by reviewing recent bank statements and comparing it with those already held. Again, however, the extent of the new verification inquiries may not need to be as extensive as the initial assessment. So, I mean, I suppose that the touchstone remains that lenders must have reliable evidence or other suitable means of verification to satisfy itself that the overall loan, including the variation, is affordable.
That's fantastic, Mark. Thank you so much. So I just want to apologise if viewers have had background noise. I'm in Auckland at level 4 and working from home, and my rubbish truck is just arriving. So my apologies for the background noise. So I just want to note that we've got about 5 minutes before we've been going for an hour, and we're really conscious of people's time. So we might just do another couple of questions if that's okay, and then the recording will be available afterwards. And remember, there is a survey at the end where you can put more questions in and we can look at how we can answer those. Mark, we had a question regarding people on work visas. So I wonder if you could, maybe if we frame it in, you know, what if a lender has an application from an overstayer whose visa has expired?
I suppose the regulations and responsible lending principles do not apply differently as such, although in this case we would expect that a lender would have difficulty satisfying itself to the as to the suitability of the borrower's likely income and expenses over the relevant period.
That makes sense. So there's a question here about getting feedback from the Commission on lenders' processes. So the question says, can lenders get feedback from the Commission on our processes, or will the Commission be doing checks?
The Commission does not approve or sign off on individual lenders' policies and processes. So lenders will need to ensure for themselves that their policies and processes comply with responsible lending obligations, taking legal advice if they need to do so. However, we are, as I think I mentioned at the start, very interested in hearing from lenders about areas or interpretation or areas of challenge around interpretation that are being faced when implementing these new changes in order for us to consider whether we may be able to provide helpful guidance to lenders to better assist them on these tricky points. So I suppose in terms of our engagement with lenders, I think we're sort of changing our approach. I think over the next years, we are looking at increasing the amount of our outreach. So meeting with lenders one-on-one to provide educational materials and to hear from you. So in addition to these sort of education outreach efforts, we will be, as we always do, undertaking investigations into lenders to assess whether the responsible lending principles have been breached. Typically, we do this as a result of a complaint, but not always. And we sometimes also use our monitoring powers to better understand compliance across a whole sector or part of a sector, for example, the high-cost loan sector or mobile traders.
And there's been lots of good work done on that. So I think we'll just do one last question, and that's in relation to a trust. So the question comes through from someone who provides, they're a trust, and they provide an opportunity for families to purchase Chromebooks for children's education. It's about a $500 cost. The verification process, that is, you know, proof of income and expenses, is way beyond their resourcing capacity, which is what they're saying. They're wondering if there's any likely dispensation for organisations like those.
I think the short answer is no. So the responsible lending obligations apply to everyone who's a lender as defined in the Act, and some mobile traders. So there are no exemptions based on charitable status, the size of the lender, the size of the loan, or the loan purpose.
Okay, that's great. Mark, thank you so much. I think we're just coming up to an hour, and we're just really conscious that everyone's day, that everyone's got busy days. So we might wind up now. Also want to acknowledge that it's an awful lot to take in over Zoom. So thank you all for your patience. Mark, is there anything else that you'd like to add?
I don't think so. That's all from me. Thank you.
That's great. Thanks, Mark. And thanks to all of you for watching and engaging with this webinar. I hope it's given you a deeper understanding of the law changes around responsible lending. Like last time, we're running a survey where you can let us know what we've missed or areas that you would like more details around. So at the end of this session, when you close the window, you will be redirected to an anonymous survey. You can pop any questions in here and let us know what you thought of the seminar as well. It helps us to improve. So when the window comes up, click continue to go to the survey. And any questions that you've got about this session or any of the other sessions, you can email us at credit.advocacy@comcom.govt.nz. Now, we've got 2 more sessions today. We've got due diligence led by Alex Smale, which starts at 12, and disclosure led by Crystal Uden, and that's at 3:30. So I might see some of you again soon. So kia ora koutou for your great listening skills. I'll close as we started with karakia. Unuhia, unuhia, unuhia ki te uru tapanui, kia wātia, kia mama, te nāko, te tiana te wairua I te ara tangata, koe rā e rongo, whakaere ake ki runga, kia tine, tine huie, tai kie. Thanks very much, everyone. Haere rā.